Before this courtroom even gets in full swing, you're about to witness something that happens far more often than people realize, but almost never goes this far. A simple traffic case, no insurance, minor violations, the kind of case that usually gets wrapped up in minutes with a fine or a quick plea deal. But not today, because instead of handling this like a routine case, the defendant is about to challenge the entire system itself, questioning the court's authority, jurisdiction, legal structure, and even the identity of the parties involved. That sounds complicated, it is. This is the kind of strategy often seen in what courts refer to as sovereign citizen-style arguments, where defendants attempt to separate themselves from the legal identity being charged, reject jurisdiction, and demand things like verified claims, certified accounting, and procedural technicalities that don't actually apply in criminal court. Now here's the twist. The judge isn't confused, he's seen this before. And instead of entertaining it, he keeps bringing the conversation back to one simple question. Are you pleading guilty, or are you going to trial? But as you're about to see, that simple question turns into a long, frustrating back and forth that slowly escalates. So, the real question for you is this. Is the defendant standing up for his rights or completely misunderstanding how the law actually works? Let's watch how this unfolds.
Your Honor, I do know I did speak with Mr. Whitford, who's here again this morning or this afternoon. I did speak to him before docket this afternoon. I think we're kind of in a position where I would imagine it's going to be set for trial. So I don't know if you want to call him. I did ask him if he wanted to retain counsel. He indicated he doesn't need counsel. So
okay, I think it's no insurance and some traffic things. Is that right?
Yes, Your Honor. The question was when we were back in court. Do you want me to wait?
Yeah, let me go ahead and call it. We're on the record on People's State Call versus Eric Whitford. Mr. Whitford, you go to the lectern there. 25T588, appearances starting with the prosecution.
Darren Betkowski for the people.
All right, and Mr. Whitford appears without an attorney. Go ahead with respect to your understanding of the status of the case, Mr. Betkowski.
One of the major points of contention is what happened to Mr. Whitford's vehicle. There was some confusion by the court as to why his car would have been towed. I did reach out to the police department on that. What I received back, Your Honor, was essentially an abandoned vehicle cover sheet. They said it was treated as an abandoned vehicle, reasons for tow. The best they have in there is just a check mark on the impound lot.
Okay.
But from my understanding and reading this, it's pursuant to CRS 42 for 1801, 1804, notice of towing from a public place.
Okay. Mr. Whitford, all of that has nothing to do with the charge against you in this case, and none of that's admissible at trial. But if you want to plead not guilty, the failure to have insurance, then we can set it for trial.
Actually, I have some procedural questions real quick.
All right.
Is this court subject to the Colorado Rules of Civil Procedure?
No, because this is a criminal court. The rules of civil procedure apply to civil cases.
Am I not being charged with civil offenses?
No, you're being charged with criminal offenses.
All three of these
the insurance is a criminal offense. The other two are, you're correct, are by statute and by rule considered civil issues.
Then wouldn't
the rules of civil procedure don't apply to them?
It doesn't apply to them?
No.
Okay, so is this court subject to the rules of the Constitution and the Bill of Rights?
Yes.
Is this a common law court or a admiralty law jurisdiction court?
It's not an admiralty court. We have nothing to do with maritime.
Right here is where things start to go off track. And if you know courtroom dynamics, this is a major turning point. The defendant is asking about civil procedure, constitutional application, and even whether this is an admiralty court. But here's the key issue. He's mixing completely different areas of law. Criminal court follows criminal procedure. Civil rules don't apply here the way he thinks they do. And admiralty law, that's for maritime cases, ships, oceans, not traffic violations. What the judge is doing is actually very important. He's trying to simplify the situation. He's not debating theory. He's focusing on procedure. Plea or trial, that's it. But instead of engaging with that reality, the defendant keeps shifting into technical arguments that don't change the outcome of the case. And this raises an interesting question for you watching. Do you think the defendant genuinely believes this strategy will work? Or is this just delaying the inevitable? Because from a legal standpoint, this isn't strengthening his position. It's isolating him.
Do you want to enter a not guilty plea and set the case for trial, or do you want to see if you can resolve the case by plea agreement with the DA? Those are the only two things I need to find out from you.
I haven't been offered any type of plea agreement yet.
Your Honor, we would be happy just to have him plead to the no proof of insurance and be done with it.
All right. You want to print out a proposed plea, and then Mr. Woodford, I'm going to have you look at that. It'll set forth what the fine for that is. If you decide you don't want to accept that plea, we can enter a not guilty plea on your behalf and set the case for trial. And
I'd rather just enter the not guilty plea.
All right. We'll get the case set for trial. Speedy trial deadline will be 6 months from today. Give me a second. We'll get your trial date. It's going to be in it'll be in April, given the number of cases we have set. Do you intend to hire an attorney?
No, I'm not a meddling volunteer or a ward of the court.
All right. You're going to try and do the jury trial on your own?
Absolutely.
Okay. Let's try April 29th. This should be a case that we can finish in one day. So April 29th at 8:30 will be the jury trial date. The pretrial readiness conference for that will be on Friday, April the 17th at 10:30. That pretrial readiness conference, Mr. Whitford, we set more than one case for trial every week just because of the number of cases we set for trial. The pretrial readiness conference is to determine whether your case or another one is going to go to trial. What determines that is the case that is closest to its speedy trial date being up goes. I'm fine with you appearing virtually in that April 10th date. I'm not going to set a motions hearing date. I do want to set, it wouldn't hurt for you to observe a trial. Cases are live streamed, and there's live stream instructions on the website if you want to just go on the live stream and watch us do a jury trial so you can see how a jury is selected and how a trial proceeds. You're certainly welcome to do that.
I've been through several trials, won a few of them by myself so far.
Okay, you're not the first person who's told me that. The last person that told me that broke down in tears when we started the trial, but I'm not saying that'll be you, but you're not the first person I've heard that from. You've done a jury trial before?
Yes, I have.
Okay, all right, fair enough. If you have a seat, I'll have my staff get you notice with the dates on it so you don't have to try and remember.
I do have one other question. The entity known as the People of the State of Colorado, is that a creation of the state?
I would say it's a creation by the legislature, so yes, I guess you could call it a creation of the state.
Okay, thank you.
All right, just have a seat. My staff will call you when you have that notice.
And Mr. Anthony Meyer. Please come up to the podium so you can be on a microphone, otherwise your statements won't be recognized.
I'm Anthony Meyer. And appear by special appearance to challenge jurisdiction.
Wait until you're at a microphone, sir, so you're being recorded, please.
Okay, very well.
There at the podium.
Approach special appearance only, not as the named entity.
Come on up to the microphone, please. Let me ask, are you Anthony Meyer? Yes or no?
I am Anthony Meyer and appear by special appearance to challenge jurisdiction and confirm administrative default to avoid joinder. And I am approaching under special appearance and not as the named entity.
This is the case of the People versus Anthony Meyer. Are you Anthony Meyer? Yes or no? And that will determine whether or not there's a failure to appear today.
I am, Your Honor, I stated that I am Anthony Meyer.
Okay,
Hereby
so
special appearance.
Mr. Meyer, you've already made your statement. You've made your
You're
statement.
interrupting me, please.
You've already made your statement this morning. Now,
Anthony
we need to
Meyer,
reset
and
the case for
hereby
trial.
Special.
You've already
appearance.
said that, right?
I'm only here to settle the accounting.
So you have two options. You can go to trial, or you can plead guilty or no contest to the charge of no insurance. You want to have the
I'm
case
here in-
reset for trial? Yes or no?
I'm here in honor to settle the matter.
Then let's settle it. If you want to know proof of insurance, you can take that. If you want to go to trial, you can do that.
Can you have the DA read the charges into the record?
You're charged with no proof of insurance. You can plead guilty, no contest, or proceed to trial again.
I don't see any proof of the charging instrument and
You
or
were
any of
issued
the
a summons and
certified
complaint
accounting.
that's adequate to inform you of the charges. You test or stand by the not guilty plea that was entered by the court on your behalf, and we will reset the case for trial. How would you like to proceed?
Before this court can proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with firsthand knowledge.
That's inaccurate. We're going to set it for trial again.
Jurisdiction remains unanswered, and there is an unrebutted administrative judgment on the record, and I request for dismissal.
A motion to dismiss denied. Let's set it for jury trial on, I got speedy trial restarting as of today's date.
Your Honor, for the record, I do not see the officer present in the courtroom, and without a sworn complaining witness with firsthand knowledge, I move the matter to be dismissed.
Motion to dismiss is denied. The officer does not have to be here today. We're going to set it for jury trial on May 7th
I have
at 8:30.
I've yet to see an offer from the DA. Can Mr. Epson please read the charges into the record?
The offer is no proof of insurance.
Okay,
guilty.
can I see those charging instruments and the certified accounting for that?
We're done.
I do not see the certified accounting for the charges or the charging instruments, and I again request dismissal. I'm hereby special appearance to confirm the administrative default. I've given you guys the motion, or sorry, the notice. I've given you guys the notice, order, and the motion to dismiss, and I've also put into the record an acceptance of offer. And again, Anthony Meyer, the living man, accepts the presentment of the offer for the case number 23T0294 to set off, settle, discharge, and close all accounts, including but not limited to the equitable subrogation IRS 941, the 941V, the 1099A, C, and OID, or supplied supersedes bond. I, Anthony Meyer, the living man, does not consent to go to prison on behalf of the named defendant, estate Anthony Janae Meyer.
Mr. Meyer, your motions are non-persuasive and essentially gibberish. Motions to dismiss are denied. The case is being reset for jury trial.
And there it is, the moment where the court draws a hard line. After all the arguments about jurisdiction, administrative defaults, and complex filings, the judge makes it crystal clear none of it is legally persuasive. And here's why that matters. In criminal court, motions have to be grounded in actual law that applies to the case. If the arguments are irrelevant, unsupported, or simply don't make legal sense, the judge doesn't have to entertain them. And that's exactly what's happening here. Notice something else, too. The judge even calls the arguments gibberish. That's not just frustration. That's a legal dismissal of their validity. At this point, the case is no longer about debate. It's about process moving forward. Trial is now inevitable. So, let me ask you this. If you were in this situation, would you continue pushing the same arguments? Or would you change strategy before it's too late? Because right now the courtroom isn't slowing down. The consequences are getting closer.
What happens if you pull this at a jury trial? It will register as a failure to appear. A new warrant will issue, and we'll keep going through this
I'm here in
until
honor.
you show up and acknowledge in front of a jury that you are Anthony Meyer. So again, you can go back to trial. We've set a trial date, or you can plead guilty or no contest. Last chance. Want to set it for trial? Yes or no?
Again, I'm here by special appearance to challenge
Okay, we're
the
going to
jurisdiction.
trial May
and to confirm
7th
the
at
administrative
8:30.
default.
We're going to do a status pretrial conference with a mandatory appearance.
I'm here in honor. And the DA has yet to present me anything, no offer, has showed no proof. Officer is nowhere to be seen. I'm present right here in front of you. You're saying that I'm not here. I'm
Judge, for the
telling you that I'm
record-
here especially.
For the record, the officer was here
No,
on
he wasn't.
Thursday, Both officers one came in from Forest and one came in from Park County.
The officer does not,
These
Mr.
officers,
Meyer, the officer
but
does not
Brock-
have to be here today.
He's
You
never
are-
been here for for
was-
not the arraignment, not for the hearing, nor was he here for the jury. And then you
Had-
said that I wasn't here last time when I was present right here in front of you,
I called
telling
for
you.
Anthony Meyer twice. You refused to have a seat, so I found you failing to appear to be tried.
And I was telling you that I'm here by
Had you taken
special
your
appearance.
seat, had we sworn a jury and had the officer not appeared, it would have gotten dismissed. That didn't happen because you failed to take your seat at the defendant's table. So,
I was willing to take my seat,
No,
Your
you
Honor.
were
I just
not.
wanted to let you know that I was here by special appearance to settle the matter.
Okay.
And again, today I'm here only to settle the matter.
the only way to settle it is to plead guilty or no contest.
Are you practicing law from the bench?
No.
No, I'm
Okay,
making the
we're
offer.
done.
Consider a plea on my behalf the first time.
As the statute authorizes, if someone refuses to plea, the court can enter a not guilty plea. So head down the hall, they'll get your paperwork. We'll see you here in person, March 4th at 3 o'clock for pretrial conference. And the case is set for jury trial May 7th at 8:30.
You guys have my offer, and so I'm waiting for the certified accounting and for the instrument for this to be able to proceed forward. So
Don't hold your breath. Go down the hall to the
We'll be
clerk's
the same.
window. Thank you.
Thank you, Your Honor.
All right, let's go to Mr. Anthony Meyer. Case number 2023 T294, appearance on bond. Case is currently set for jury trial. Take two on May 7th at 8:30. Good morning, Mr. Meyer.
Good morning, Your Honor.
Any questions to begin with?
I, Anthony Meyer, am appearing specially, not generally, on behalf of the named defendant estate, also known as Anthony Janae Meyer, here to challenge jurisdiction and to confirm the administrative default and to avoid joinder. And only here to settle the accounting.
So to summarize your options again, of course, you're presumed innocent. We have you set for a jury trial. Other options to enlist the services of an attorney or plead guilty or no contest to the charge. Mr. Ibsen, is there a stipulated plea offer regarding any potential jail time?
Judge, I was going to make the defendant a plea offer actually, I was going to offer a deferred judgment to no proof of insurance for a year with 60 days jail suspended on condition that he provide proof of insurance to the court every month. Court of probation.
So there's a plea offer that includes a deferred judgment with required ongoing proof of insurance, or you can plead guilty or no contest with a fine and court costs, 4-point assessment against your driving privileges, or of course, carry on with the jury trial scheduled in May. Mr. Meyer, of those options, do you want to continue with the trial setting?
I would say at this time, I have put in the notice motion in order, and before the court could proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with the firsthand knowledge. And would like to see if I could have a written response to my offer and 72 hours to review with my attorney.
You do have the right to discovery. Have you requested that from the DA's office?
I have not.
So you can make a request for discovery. That'll give you the police reports and other discoverable information in the file, any body cam video of the incident, anything that the state has to provide to you under Rule 16. Then you can assess that evidence and decide how best to defend yourself at trial if you want to continue with the trial. You do have the right to confront any of the state's witnesses. That right means that at trial, those witnesses would be called, put under oath, and you could cross-examine them. You do have the right to present your own evidence, though you don't have to. It's the state's burden to prove the charge beyond a reasonable doubt. You don't have to take the stand or call witnesses, but you, of course, have the right to if you choose to. Other than that, the court has denied your motions to dismiss. The complaint filed in the case is adequate under Colorado law to advise you of the nature of the charge, date, place, and time. So we are going to proceed to trial unless you choose to take a different path. Any additional questions today?
I would just say that I still don't understand the charges. I haven't seen the charging instruments and or certified accounting. And at this time, jurisdiction remains unanswered. And there's an unrebutted affidavit or administrative default judgment on the record. And again, I just request dismissal.
The motion to dismiss is denied. The complaint that you were issued by the officer is adequate to inform you of the charge. That's a charge of operating a vehicle without showing proof of insurance. It indicates the date, place, and time, that being within Park County, thus conferring jurisdiction on this court. So the next court date.
Shows there was a pre-trial for tomorrow. I'm not sure if that could be pushed out or could also be pushed to Zoom. I actually don't reside in this state. I'm kind of here because I have to be. And so, yeah, either if I could do a Zoom for tomorrow and or it could be pushed out a little bit. I guess there's a few additional things I could request and or file.
Okay. So you're currently on bond. The court, Mr. Ibsen, any objection to modifying bond to allow Mr. Meyer to leave the state
No, sir.
pending the trial?
No.
Okay, so the bond is not forfeit. It continues. That's $1,000 cash bond posted last time. We'll continue the bond until the case is resolved. Modify the bond to allow you to leave the state. Are you residing in Arizona?
Florida.
Florida now, okay. The next court date that the court is showing is the jury trial. Well, we've got a pretrial readiness tomorrow, okay, that's what you're referring to. I propose we vacate that.
Okay.
And we just leave it on for trial May 7th at 8:30. You would have to be here in person for that.
Oh, yeah. And could I add one more thing?
Sure.
I would like to motion and order this court to revoke and revest the court's case trust securities. And I'm motioning and ordering the court and the state to produce the IRS 1099-A QSIP, bid bond, performance bond, and payment bonds for set-off, settlement, adjudication, adjudicate all claims, balance all the accounts to zero, discharge and close all accounts, and return remain funds to me and dismiss the case with prejudice. Unless I can get the certified accounting, just because this would be a concealment of my tax records.
I have no idea what you're asking. So the motion's denied as inapplicable, incomprehensible, and unpersuasive entirely. So the case remains set for jury trial May 7th at 8:30. Next time, if you're not here, a warrant issues. If you're here and refuse to acknowledge your presence, but I know you're here, the issue would be either to issue a warrant, take you into custody, or proceed with you in absentia, noting that you're present but refusing to participate. So you can show up and participate. You can show up and refuse to participate. In other words, not have a seat at the defense table and acknowledge that you're the individual named Anthony Meyer. And then at that time, I'll decide whether to put on the trial anyway or take you into custody again and go through the whole bonding out and keep this cycle going.
I have the right,
Or you can refuse to come and we'd issue a warrant.
I have the right to appear specially and not generally though, correct?
No.
No, you have to appear as Mr. Anthony Meyer. If you do not, but I know you're sitting in the audience, I may decide to put on a trial with you in absentia that you're refusing to participate but are present, or I'll issue a warrant and have you taken into custody. Those would be the options if you're not willing to have a seat at the defense table acknowledging that you are Mr. Anthony Meyer. Okay?
Okay.
Any other questions today?
Judge, just for the record, and I want to make sure the record's clear on this. Ms. Lindsay checked our records. We have given Mr. Meyer discovery in this case.
Okay. Thank you, sir.
Okay.
So that'll do it for today. Head down the hall if you want a printout of your next court date. Of course, that is the jury trial. You need to be here at 8:30, May 7th, acknowledging that you are Mr. Anthony Meyer, the accused. If you refuse to do so, I've explained what the court's options are, limited to a warrant or proceeding against you in absentia, noting that you are present but refusing to participate. So we'll see you in May, sir.
Awesome.
Thank you.
Thank you very much, Your Honor.
We'll take a recess until 11 o'clock for advisement.
And just like that, this entire courtroom exchange comes to a close. But the bigger picture is what really matters here. What started as a simple no insurance case turned into a full-blown clash between legal reality and personal interpretation of the law. The defendant repeatedly challenged jurisdiction, demanded documents that don't apply in criminal proceedings, and refused to engage with the court in the way the legal system requires. But the judge stayed consistent the entire time. He didn't get pulled into side arguments. He didn't entertain irrelevant theories. He kept bringing everything back to the same core path. Follow procedure or face the consequences. And now the outcome is clear. The case is heading to trial, and the risks are higher than ever because in a jury trial, arguments like these won't just be dismissed. They could actively hurt the defense. So here's the real takeaway. Understanding your rights is powerful, but misunderstanding the law can be dangerous. What do you think? Was the defendant standing his ground or sabotaging his own case? Drop your thoughts in the comments. And if you found this case as fascinating as we did, make sure to hit that like button, share your thoughts, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.